Good morning. Welcome to a regular meeting of a panel of utility commissioners and staff of the Public Utilities Regulatory Authority held today, Wednesday, November 22nd, 2023 by remote teleconference. My name is Chairman Marissa Gillette, and I'm joined virtually today by my colleagues, the Vice Chairman Jack Bukowski and Commissioner Michael Karen. For today's agenda, we have both a regular calendar and a consent calendar in front of us. So we will turn first to today's regular calendar, on which there are 3 items. The first item is Connecticut Electric Aggregator Certificates of Registration. We have a batch of 5 dockets for approval this morning. So I will turn to Attorney Elizabeth Tanaka to present the decisions for the panel's consideration, please.
Good morning, Chairman Gillette, Vice Chairman Bukowski, and Commissioner Karen. Between June and September 2023, 5 applicants, JMI Consultants LLC, DNE Sales LLC, Insight Energy LLC, Breakerbox LLC, and NUS Consulting Group applied to the Public Utilities Regulatory Authority for a Connecticut Electric Aggregator Certificate of Registration pursuant to Connecticut General Statute 16-245L. In response, the authority considered the applications in 5 uncontested proceedings. The matters were delegated to the authority's Office of Education, Outreach, and Enforcement, or EOE, until EOE filed a proposed final decision addressing this batch of applications. The authority determined that each applicant satisfied the application requirements and recommends granting each of the applicants an electric aggregator certificate of registration to serve the non-residential markets requested by each applicant, subject to the conditions described in the decision. The authority determines that no applicant has met the burden of demonstrating capability of serving the residential market or working with residential customers, and all requests to serve residential markets are denied. The decision addresses the role of electric aggregators, aggregators agents, suppliers agents, and customers in the energy market, as well as permissible aggregator compensation, procedures for solicitation and communication, and contracts with suppliers. In being granted electric aggregator certificates of registration, the applicants enter a highly regulated market that requires transparency. Accordingly, the applicants must ensure that they comply with all application requirements, including statutes, regulations, and authority decisions, orders, and rulings. The authority sets forth 13 orders in this decision applicable to each of the applicants, which include orders that they eliminate prohibited types of compensation, eliminate contract provisions conflicting with their role as customer agents, maintain certain records, and comply with annual filing requirements. The authority also orders each applicant to provide customers with 3 documents discussed in detail in the decision. In short, the documents must disclose the aggregator's compensation, the process used to solicit rates, the proffered rates, and information about any contracted supplier. The authority staff recommends adoption of this decision. Thank you.
Thank you. Is there a motion?
I move adoption. Second.
Thank you. The decisions have been regularly moved and seconded. If there are no questions or comments, I would ask Mr. Bumpin to please.
Chairman Gillette,
Yes.
Vice Chairman Bukowski.
Yes.
Commissioner Karen.
Yes.
Thank you. The decisions have been adopted. The second item on today's regular meeting agenda is docket number 230132, an investigation into Eversource's manner of operation and safety regarding its underground electric distribution system. We will turn to Attorney Fryer on behalf of the authority staff to present the decision for the panel's consideration, please.
Good morning, Chair Gillette, Vice Chairman Bukowski, and Commissioner Karen. In response to a series of incidents reported by the Connecticut Light and Power Company doing business as Eversource, the Public Utilities Regulatory Authority initiated this proceeding to investigate and evaluate Eversource's practices regarding prevention of and response to accidents, including filing adequate accident reports, and determine whether the company violated any applicable provisions of general statutes of Connecticut, regulations of Connecticut state agencies, or authority orders. The investigation indicates that Eversource's accident reporting was untimely and deficient, and as such was potentially in violation of applicable reporting requirements. Further, the investigation revealed that Eversource failed to perform underground facility inspections as required by its filed maintenance plan. Between April 2022 and February 2023, Eversource filed at least 6 major accident reports related to underground electric distribution infrastructure. The accident reports arose from the following 6 incidences: electrical fault in a manhole in Middletown, fire in a network vault in Waterbury, failed splice in or around a manhole in New Britain, damaged cable that resulted in dislodged cover at a manhole in Torrington, electrical fault at a pad mountain transformer in Newington, and fire occurred where rubber insulation on the secondary cable ignited at a manhole in Hartford. The authority held a noticed evidentiary hearing on May 9th, 2023 by a teleconference. On October 24th, 2023, the authority issued a proposed final decision, and Eversource filed written exceptions on November 8th, 2023. The authority is required to examine and regulate the operations and internal workings of public service companies, such that, among other things, public service companies shall perform all of their respective public responsibilities with economy, efficiency, and care for public safety. With respect to accidents specifically, Eversource is subject to Connecticut General Statute Section 1616, which states that Eversource is required to notify the authority of any accident attended with personal injury or involving public safety, which was or may have been connected with or due to the operation of its property. Eversource is to contact the authority by telephone or otherwise as soon as possible, as soon as may be reasonably possible after the occurrence of such accident, unless such accident is a minor accident. Further, if notice of such accident is given otherwise than in writing, it shall be confirmed in writing within 5 days after the occurrence of such accident. Therefore, if the initial report is not in writing, the statute requires the company to file a confirmation within 5 days after the accident. A company failing to comply with the provisions of Connecticut General Statute Section 16-16 shall be fined not more than $500 for each offense. Additionally, Eversource is subject to specific accident reporting requirements for major accidents pursuant to Connecticut Agency Regulations 16-16-1 through 16-16-4. Pursuant to these regulations, major accidents are defined as, among other things, any explosions, major fires, or other cases of serious damage at any utility facility. Pursuant to Connecticut Agency Regulations 16-16-3, Eversource shall notify the authority of any major accident that occurred in Connecticut or affected Connecticut residents as soon as possible, but no later than 24 hours after the occurrence of the utility's discovery of the accident, which is known as the immediate accident report. Subsequent to the immediate accident report, a utility shall submit a written report of the accident no later than 5 business days after the occurrence or discovery of a major accident. In addition to these timing requirements, Connecticut Agency Regulations 16-16-3E prescribes the specific information to be included in the reports to the extent such information is known. Pursuant to Connecticut General Statute Section 16-41, any company which the authority finds has failed to obey or comply with any order or regulation shall be fined in accordance with the penalty prescribed for the violated provision of this title, or if no penalty is prescribed, not more than $10,000 for each offense. In addition, Eversource's management and operations are subject to at all times a reasonable prudent standard, particularly with respect to the company's response to accidents implicating public safety. Pursuant to prior authority decisions, the prudent standard is the standard of care a reasonable person would exercise under the same circumstances confronting the management of the utility at the time of the decision to take such actions. This proceeding required the authority to first determine if the accidents met the definition of a major accident. As previously mentioned, the major accidents include, but are not limited to, any explosions, major fires, or other cases of serious damage at any utility facility. The authority finds that the Middletown incident, Waterbury incident, New Britain incident, Torrington incident, and Hartford incident meet the definition of a major accident, as the incidents involve evidence of an explosion, a displaced manhole cover, or visible smoke and or fire emanating from the underground facility, necessitating a fire department presence. The authority finds that the Newington incident does not meet the definition of a major accident. Having made the determination that these 5 incidents meet the definition of a major accident, the 5 incidents are therefore subject to the reporting requirements of Connecticut Regulations 16-16-3, and Eversource is required to provide the authority with immediate accident report and a 5-day accident report. The following 3 reports were filed subsequent to the prescribed periods: the Middletown immediate accident report, Middletown 5-day accident report, and the Waterbury 5-day accident report. Consequently, the evidence suggests that Eversource failed to timely notify the authority and failed to submit the requisite reports in violation of Connecticut General Statute 1616 and Connecticut Agency Regulations 16-16-3A and B. Next, the authority reviewed the accident reports for deficiencies. The reports filed by Eversource along with required supplements shall include 9 discrete types of data to extent known for each incident as required by 16.16.3E. Here, despite having responsive information at the time of the company completed the reports, Eversource failed to provide sufficient information, including by leaving relevant fields in the report forms blank in both the immediate and 5-day accident reports in relation to the Middletown incident, Waterbury incident, New Britain incident, Torrington incident, and Hartford incident. The authority also reviewed the company's compliance with their maintenance plan. Eversource is required to and did submit an annual maintenance plan to the authority. Under the Eversource Electric Utility Line Maintenance Plan 2022, the company is to inspect manholes every 5 years. In 4 of the 6 incidents, the manhole inspections were not inspected in accordance with the company's maintenance timeframe. Those incidents are Waterbury, New Britain, Torrington, and Hartford. The company's failure to complete required inspections with respect to those 4 locations may have contributed to these events at issue in this proceeding. The failure to conduct the inspections raises serious concerns regarding the company's managerial oversight and whether the company is prudently and efficiently operating its franchise. Importantly, the authority previously noted deficiencies in the company's execution of its routine maintenance relating to underground facilities in the September 15th, 2006 decision in docket number 060820, the DPUC report for the Governor on Electric System Infrastructure and Policies. The company's failure to complete the inspections of underground facilities in accordance with this maintenance plan appears to be inconsistent with the degree of care and skill which may be reasonably expected of intelligent and prudent persons. And as a result, the authority may consider whether the company's lack of compliance with its maintenance plan evidences imprudent and efficient management to an extent that it warrants an adjustment to the company's rates. The investigation identified certain deficiencies in Eversource accident reporting that may be in violation of the applicable reporting requirements. Further, this investigation indicated the Eversource has not complied with portion of its payment of its maintenance plan. The authority orders by January 15th, 2024, and annually thereafter until its next rate proceeding, the company shall submit a report to the authority in this docket that identifies any non-compliance with the company's maintenance plan. The report shall state the cause of the non-compliance and any corrective or remedial action by the company to address the non-compliance. The authority staff respectfully requests that this decision be adopted as a final decision. Thank you.
Thank you. Is there a motion?
So moved.
I will second. If there are any questions or comments before we vote.
Madam Chairman. Madam Chairman, just for the panel's awareness, I am not familiar with this record. I know I was out of the country during the public hearing for this particular docket, and consequently, don't feel well versed enough in it to take a vote. So consequently, I shall be abstaining on this particular docket.
Thank you, Commissioner Karen. So noted. There is nothing further.
Madam Chair, if I may, I want to thank the staff for the excellent work on this case and for the in-depth research and the recommendations that are being made. And it's certainly going to hopefully develop a roadmap for the company moving forward, so we will not have incidents of this nature in the future. Thank you.
Thank you, Mr. Vice Chairman, and note that they are building on the report and observations that you saw in a 2006 docket. So building on that prior record.
Probably the lead on that docket, I would imagine.
All right, thank you. Then Mr. Bumpin, if you can please take the roll.
Chairman Gillette,
Yes.
Vice Chairman Bukowski,
Yes.
Commissioner Karen,
Abstain.
So the decision is approved. Well, the third item on today's regular meeting agenda, docket number 230827, the application for temporary master meter approval at 9 Third Bridge Road, Newtown, Connecticut. Mr. Capozzi is here to present the decision for the panel's consideration, please.
Thank you, Chairman, and good morning. Good morning, Vice Chairman Bukowski and Commissioner Karen. On August 28th, 2023, Covered Bridge Newtown LLC requested permission from the authority to master meter on a temporary basis at 2 buildings at the address 9 Covered Bridge Road in Newtown. Connecticut Agency Regulations 1611-116 effectively prohibit master metering by requiring individual dwelling units in an apartment to have individual electric distribution company revenue meters installed. The primary reason for this prohibition on master metering is that so customers receive price signals directly on their usage, on their electric usage, and which empowers customers to manage their energy usage, and it promotes conservation. That regulation also enables Connecticut Agency Regulation 1611-116 enables the authority to grant an exception to that prohibition. In this docket, the company has experienced delays receiving electric service equipment necessary to install individual utility meters due to supply chain issues, and therefore requests permission from the authority to temporarily master meter until such a time as it receives the equipment from the manufacturers. The authority has reviewed the application in this case and finds that since the company is requesting master metering only on a temporary basis and plans to install individual utility revenue meters when it receives the necessary electric service components, the authority grants an exception or an exemption from the prohibition on master metering. To ensure that the master metering is indeed temporary and that the company ultimately converts to individual utility meters, the authorities has included orders to keep apprised of the company's progress in receiving the necessary electric service equipment. And also the authority establishes a deadline by which the company has to convert to individual utility meters. The company may request an extension depending on its ability to receive the equipment. But thank you very much for your attention, commissioners, and the authority staff recommend this decision to the panel for adoption.
Thank you, Mr. Capozzi. Is there a motion?
Move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. There are no questions or comments. I'd ask Mr. Bumpin to please take the roll.
Chairman Gillette,
Yes.
Vice Chairman Pekoski.
Yeah.
Commissioner Karen,
Yes.
Thank you. The decision has been adopted. We'll turn next to our consent calendar in which there are 12 items, and I will seek a motion, please.
Madam Chairman, I would move today's consent calendar, items 1 through 12.
Second, Madam Chairman.
Thank you, gentlemen. The consent calendar has been regularly moved and seconded. Mr. Bumpin, please take the roll.
Chairman Gillette,
Yes.
Vice Chairman Pekoski,
Yes.
Commissioner Karen,
Yes.
Thank you. The consent calendar has been adopted in full. That brings us to the end of today's regular meeting agenda. We will adjourn. We will reconvene next Wednesday, November 29th at 10 a.m. by remote teleconference for our next regular meeting. Thank you very much for your attention and attendance. We will adjourn. Wish everyone a